The Trans-Pacific Partnership is a multilateral free trade agreement under negotiation. The Advanced Intellectual Property Chapter for all 12 nations with negotiating positions was published by Wikileaks on 13 November 2013. Previously, the U.S. proposal for the chapter had been leaked by U.S. Congressman Darrell Issa in May 2012. Other drafts available are from February 2011 and September 2011. The latter focuses on patent. The intellectual property provisions are a source of controversy, especially in terms of their effects on pharmaceutical patents and digital innovation. TPP members agree that they will follow and expand upon the legal rights and obligations delineated in the World Trade Organization Agreement on trade-related aspects of intellectual property rights, and the agreement's discussions thus far have included trademark, geographical indication, copyright and related rights, patents, trade secrets, genetic resources, and traditional knowledge. Furthermore, statements from former U.S. officials indicate that the agreement is intended to set the bar for future agreements. Intellectual property section. The language of the TPP borrows heavily from the Anti-Counterfeiting Trade Agreement, the most recent intellectual property agreement that applies to all TPP members is TRIPS. Article 2. Trademark. The trademark provisions of the TPP contain similarities to current United States trademark law and in several instances call for a higher level of protection than in the TRIPS agreement. Scope of trademark. Article 2.1 of the TPP states that no party may require, as a condition of registration, that a sign be visually perceptible, nor may a party deny registration of a trademark solely on the grounds that the sign of which it is composed is a sound or a scent. This mirrors the scope of trademark in the Lanham Act. This places an obligation on TPP members to grant trademarks that they could reject under TRIPS, which allows a member to require, as a condition of registration, that signs be visually perceptible. The language of this article also duplicates the wording of the trademark provision in the Korea-US Free Trade Agreement. Exclusive use rights. Article 2.4 provides the owner of a registered trademark the right to exclude third parties from using it in the course of trade. Furthermore, it states that they may also exclude those using similar signs, for goods or services that are related to those goods or services in respect of which the owner's trademark is registered. The Lanham Act states that non-rights holders may not use in commerce any colorable imitation of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services on or in connection with which such use is likely to cause confusion, or to cause mistake, or to deceive. The difference in these two standards is unclear. Article 2.4 of the TPP has very similar language to the corresponding provision of TRIPS. However, TRIPS allows the trademark owner to prevent others from using the mark in the course of trade identical or similar signs for goods or services which are identical or similar. It appears that the TPP language affords greater protection to trademarks, but this is not yet clear. Well-known marks. Article 6 bis of the Paris Convention refers to well-known marks as a mark considered by the competent authority of the country of registration or used to be well-known. Such marks are to be protected outside of their home country. Article 2.6 of the TPP states that a party may not require registration of a trademark for it to be considered well-known. It states that parties may not deny relief based solely on the lack of a registration, inclusion on a list of well-known marks, or prior recognition of the mark as well-known. Furthermore, footnote 5, found in Article 2.7, states that when determining whether a mark is well known, No party shall require that the reputation of the trademark extend beyond the sector of the public that normally deals with the relevant goods or services. U.S. law does not have a legislative standard for determining whether something is a well-known mark. However, the TPP's language deviates from the TRIPS standard. According to TRIPS Article 16.2, members must only take into account the relevant sector of the public, and may therefore go beyond it. The treatment of geographical indications. Protection. Article 2.4 of the TPP provides that geographical indications are eligible for protection as trademarks. It defines geographical indications as indications that identify a good as originating in the territory of a party, or a region or locality in that territory, where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. It further states in footnote 4 that any sign or combination of signs can be a geographical indicator. The main effect of this provision is to subsume geographical indication protection into trademark law. This marks a departure from TRIPS, which deals with geographical indications in an article separate from trademark. Geographical indication versus trademark. Article 2.15 of the TPP prohibits the use of a GI where it is likely to cause confusion with a trademark. Furthermore, Article 2.18 defines a generic GI in a way that would allow one country's generic use of a term to defeat a claim of a GI that is protected in another country. Lastly, Article 2.22 allows the registration of trademarks reference a geographical area even though it is not the true place of origin. In the United States, geographical indications are treated in a manner almost identical with trademark law, so this merging of doctrines will have little effect. However, the language of the TPP deviates from that of TRIPS, where the TPP focuses on confusion with a trademark. TRIPS regulation of GIs requires members to enable the prevention of the use of any means in the designation or presentation of a good that indicates or suggests that the good in question originates in a geographical area other than the true place of origin in a manner which misleads the public as to the geographical origin of the good. Article 4. Copyright and related rights. Temporary copies. Article 4.1 provides that rights holders may authorize or prohibit all reproductions of their works, performances, and phonograms in any manner or form, permanent or temporary. The Digital Millennium Copyright Act does not provide rights over temporary copies. The statute's definition of copies as material objects that are fixed indicates that temporary storage of copyrighted material would not infringe. In addition, 17 U.S.C. 512 specifically provides that Internet service providers are not liable for infringement by reason of the intermediate and temporary storage of material. There is some debate in the U.S. federal courts regarding liability for temporary copies, beginning with My Systems Corp. v. Peak Computer, Inc., which held that temporary copies stored on RAM may infringe. Recently, however, several courts of appeals have found that qualitatively transitory copies do not violate the DMCA. ACTA does not define copyright rights, and TRIPS references the Berne Convention, which contains no language regarding temporary copies. Parallel imports. Article 4.2 provides that rights holders may authorize or prohibit parallel imports. In March 2013, the United States Supreme Court decided in Kurtzahn v. John Wiley & Sons, Inc., that the first sale doctrine applies to works manufactured outside the United States, establishing the legality of parallel imports. Likewise, New Zealand lifted a ban on parallel importation in 1998 and has found that the decision has not had a negative impact on New Zealand's creative sector. TRIPS provides that nothing in this agreement shall be used to address the issue of the exhaustion of intellectual property rights, effectively allowing each country to determine their own exhaustion regime. ACTA does not address parallel imports. Copyright terms. Article 4.3 provides that copyright terms shall be not less than the life of the author and 70 years after the author's death. TRIPS, on the other hand, sets the term at 50 years. In addition, 4.3 does not provide a presumption for the author's death, unlike 17 U.S.C. 302. ACTA does not address copyright duration. Anti-circumvention. Article 4.9 is similar to U.S. law on anti-circumvention. However, there are some differences between Art. 4.9, U.S. law and other agreements. ACTA and KOR-US, for example, require knowledge that one is circumventing a technology measure, while Art. 4.9 and U.S. law do not have knowledge requirements. Art. 4.9 provides that prohibited devices and services include those that enable or facilitate circumvention, whereas the DMCA and ACTA only prohibit devices and services that have the purpose of circumventing. Article 4.9 provides that any violation under Art. 4.9 is of separate cause of action, independent of any infringement that might occur under copyright. There is a Circuit Court of Appeals split on this issue between the Ninth Circuit, holding the view reflected in Art. 4.9, that is, that you may be guilty of circumvention even if you do not violate a copyright, and the Second Circuit, which has held that an underlying copyright must actually be infringed to trigger circumvention liability. TRIPS does not address anti-circumvention rights management information. 4.10 provides for civil liability if 1. distributes, imports for distribution, broadcasts, communicates or makes available to the public copies of works with removed RMI. This language is identical to ACTA Article 27.2. It is broader than U.S. law, which imposes liability only for distribution, importing for distribution, or public performance. Article 5. Making available distribution, making available. Article 5 provides that authors have the exclusive right to authorize or prohibit the communication of their works, including making available their works in such a way that the public may access these works from a place and at a time individually chosen by them. U.S. law, on the other hand, only provides the following rights: sale, transfer of ownership, rental, lease or lending. There is a U.S. District Court split on whether 106 includes making available right absent actual transfer of the work. The making available right has been advocated by the RIAA in cases like Electra v. Baker, Atlantic v. Howell, and Capital v. Thomas. In all three cases, the court either declined to address the argument or found that 106 was not violated unless the alleged infringer actually distributed the work. The Commercial Felony Streaming Act criminalized streaming for financial benefit, arguably establishing at least a narrow making available right. Article 8. Patents definition. Article 8.1 sets forth the availability of patents, and provides that patents shall be available for any new forms, uses, or methods of using a known product, and these may satisfy the criteria for patentability, even if such invention does not result in the enhancement of the known efficacy of the product. TRIPS, on the other hand, specifies that patents are available, provided that the invention is new, involve an inventive step and is capable of industrial application. Flynn et al. Note that Art. 8.1 is inconsistent with the laws of many TPP member countries, and may also directly target India. Disclosure. Article 8.10 provides disclosure of claimed invention requirements. It does not include, however, a requirement that the inventor indicate the best mode for carrying out the invention. The best mode requirement is included in both U.S. law and TRIPS. The purpose of the best mode requirement is to ensure full disclosure, such that the inventor may not disclose only what he knows to be his second best embodiment, retaining the best for himself. Article 12. Civil enforcement damages. Article 12.4 mandates the creation of a system of statutory damages and specifies that damages shall be sufficiently high to constitute a deterrent to future infringements. ACTA does not require that a member use statutory damages, but allows it as an enforcement option. TRIPS allows statutory damages to be used where they exist, but does not require their creation. U.S. law does not include a deterrence requirement, and only allows increased damages for willful violations. Destruction. Article 12.7 sets destruction of pirated or counterfeit goods as the norm. It also specifies that materials and implements that have been used in the manufacture or creation of such pirated or counterfeit goods be promptly destroyed. This expands upon both U.S. law and TRIPS. U.S. law provides a specific list of implements that may be destroyed, and TRIPS narrows the materials that may be destroyed to those the predominant use of which has been in the creation of the infringing goods. In addition, TRIPS does not establish destruction of goods as the norm, but provides for destruction or disposing the good outside the channels of commerce. Article 13. Provisional measures. Preliminary injunctions. Article 13 sets forth procedures for granting a preliminary injunctions. Article 13.1 provides that preliminary injunctions should be granted expeditiously, and, except in exceptional cases, requests should be executed within 10 days. This differs from U.S. law, TRIPS and ACTA, none of which have explicit time requirements. ACTA, for example, provides that authorities should have the authority to make decision without undue delay. Additionally, TRIPS and ACTA both specify that preliminary injunctions are appropriate in cases where delay is likely to cause irreparable harm to the right holder. Art. 13.1, on the other hand, does not seem to require irreparable harm to the holder. Article 13.2 sets out the standards an applicant for a preliminary injunction must satisfy, stating that applicants may be required to provide any reasonably available evidence in order to satisfy the authorities with a sufficient degree of certainty that the applicant's right is being infringed. U.S. law, on the other hand, has much more stringent requirements for preliminary injunctions, requiring a showing that irreparable harm will be likely, balancing the harms of an injunction, and considering the public interest. As noted above, both ACTA and TRIPS contain identical irreparable harm language, which corresponds to the U.S. irreparable injury requirement. Article 15. Criminal enforcement. Willful. Article 15.1 provides for criminal penalties in cases of willful copyright infringement on a commercial scale. It notes that willful copyright infringement on a commercial scale includes significant willful copyright or related rights infringements that have no direct or indirect motivation of financial gain, in addition to infringement with financial gain as the motive. This differs from ACTA, TRIPS and U.S. law. ACTA specifies that willful infringement on a commercial scale includes that motivated by financial gain, but says nothing about infringement lacking such financial motives. TRIPS does not specify what qualifies as willful copyright on a commercial scale, but the U.S.-China WTO case decided in 2010 determines commercial scale by looking at the typical or usual commercial activity with respect to the product and specific market involved. U.S. law contains a financial gain motivation requirement and also may find infringement without financial gain, but where the goods distributed or reproduced would retail for $1,000 or more.